Hello students, today we are going to discuss very important topic of CPC, that is res sub judice. Res sub judice has been given in section 10 of CPC. Section 10 states, if a person filed similar type of suits against the same person having the same cause of action and having the same issues, then the second suit which was filed thereafter shall be stayed. What is stating in section number 10? Now let us discuss the bare language of section 10. It tells, no court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in the previously instituted suit between the same parties or between parties under whom they or any of them claim litigating under the same title, where such suit is pending in the same or any other court in India, having jurisdiction to grant the relief claimed, or in any court beyond the limit of India, established or continued by the central government, and having like jurisdiction or before the Supreme Court. It simply states that trial shall not proceed further in any suit if the matter in issue is also directly and substantially in issue in a previously instituted suit, and that suit may be between the same parties or between parties under whom they or any of them claim litigating under the same title, and that previously instituted suit may be pending in the same court or in any other court in India having jurisdiction to grant the relief claimed, or that suit which was previously instituted may be pending in any court which is situated beyond the territory of India, and that court may be established or continued by the central government of India and have like jurisdiction, or that previously instituted suit may be pending in the Supreme Court. But it is very important to note the explanation of section 10. What explanation states? It states the pendency of a suit in a foreign court does not preclude the courts in India from trying a suit founded on the same cause of action. What is the object to enact section 10? First object is it avoids two parallel litigations that are similar in respect of cause of action, that are similar in respect of subject matter, and that are similar in respect of relief in two courts. The second object, it protects a person from multiplicity of proceedings. For one cause of action, for one subject matter, and for one relief, there should not be two suits. And it avoids the conflict of decisions that may be when two instituted suits are decided by different courts. And what is the scope of section 10? Section 10 simply bar the trial of the suit and not the institution thereof. You can file the second suit, but trial shall be barred. It also does not preclude a court from passing interim orders, such as the court can grant the injunction, the court can grant the stay, the court can appoint the receiver, etc. in the second instituted suit. But what are the various conditions for the application of Section 10? How the suit shall be stayed by the civil court by applying the provisions of Section 10. The first condition is that there must be two suits. One previously instituted suit and the other subsequently instituted suit. So there must be two suits, one previously instituted suit and the other subsequently instituted suit. The matter in issue in the subsequent suit must be directly and substantially in issue in the previously instituted suit. Okay. Third condition, the previously instituted suit must be pending in the same court in which the subsequent suit is brought, or in any other court in India, or in any other court beyond the limit of India, which court is established or continued by the central government or before the Supreme Court. The court in which the previous instituted suit was instituted must have jurisdiction to grant the relief claimed in the subsequent suit. And such parties must be litigating under the same title in both the suit. If A was the plaintiff in the previously instituted suit, then A must be the plaintiff in the subsequent instituted suit. As soon as the above 5 conditions are satisfied, then the court cannot proceed with the subsequently instituted suit, because the provisions contained in Section 10 are mandatory in nature. Because the word is written, no court shall, as the word shall is used, so the provision is mandatory. And no discretion is left with the court. The civil court has to stay the proceedings of subsequently instituted suit. The order staying the proceedings in the subsequent suit can be made at any stage of the suit. Now the question arises, when Section 10 does not apply, when the conditions mentioned in Section 10 are not satisfied, then Section 10 will not apply. Meaning to say that when parties are different, when courts have not jurisdiction, when the cause of action is different, then Section 10 will not apply and there shall not be stay on the suit. Since the provisions apply only to the suits instituted in the civil court, therefore it has no application to any other proceedings of a different nature. If you are filing the civil suit in the civil court, and on the other hand you are filing the complaint before the consumer court or before the criminal court, Section 10 shall not bar those actions, because it only bars the trial of subsequent instituted suit before the civil court. Number 3, when Section 10 will not apply, when either previously instituted suit or subsequently instituted suit is not legally maintainable. Even then Section 10 shall not apply, because this provision apply only to those suits which are legally maintainable And when the suits are not legally maintainable, Section 10 shall not apply. And what is the test for the application of Section 10? When the decision in a previously instituted suit operate as res judicata in the subsequent suit, then the principle of Section 10 shall apply, otherwise it will not be applied. We will discuss the concept of res judicata in the next lectures. I repeat, the test for the applicability of Section 10 is whether the decision in a previously instituted suit would operate as res judicata in the subsequent suit. If it is so, then subsequent suit must be stayed. So what will happen if the court want to stay the proceedings of the suit in the interest of justice, but Section 10 is not applicable? Nothing to worry. There is inherent power to stay the proceeding under Section 151 of CPC. Even where the provision of Section 10 of the code do not strictly apply, even then the civil court has inherent power under Section 151 of CPC to stay a suit to achieve the ends of justice. Whether the suit can be consolidated in one suit? Yes. Since the main purpose of Section 10 is to avoid two conflicting decisions, a court in an appropriate case, when the provisions of Section 10 are not strictly applicable, can pass an order of consolidation of both the suits. What will happen? If the parties to the suit are not objecting, are not making the application under Section 10, even then there is not any worry. A decree passed in the contravention of Section 10 is not a nullity. If there is a decree passed in subsequently instituted suit, even that decree is not a nullity and therefore cannot be disregarded in execution proceedings. Section 10 only lays down a rule of procedure, pure and simple, which can be waived by a party. Hence, if the parties waive their right and expressly ask the court to proceed with the subsequent suit, then they cannot afterward challenge the validity of the subsequent proceedings. So, this was something about section number 10. Thank you.